In our opinion, the legal position is so clear that it was not necessary for the learned counsel to refer to any judgment, and merely by showing the aforestated factual aspect and legal provisions to the concerned authority, the appellant could have convinced the concerned authority that the sale effected at the duty free shops of the appellant could not have been taxed by the state of Karnataka learned counsel appearing for the respondents. Authorities had vehemently submitted that the appellant had not exhausted equally efficacious alternative statutory remedy, and therefore the single judge of the High Court had rightly not entertained the petition filed by the appellant. According to them, the division bench had also rightly dismissed the appeal for the same reason. According to them, this court also should not entertain this appeal. It is true that the appellant had rushed to the High Court without exhausting equally efficacious alternative statutory remedy. In our opinion, the learned single judge of the High Court was also right when he directed the appellant to move the statutory appellate authority. In normal circumstances, even we would have expressed the same opinion, but looking to the fact that the special leave petition has already been admitted and the matter pertains to the assessment year 2005, it would not be in the interest of the justice to relegate the appellant to the statutory authorities, especially when the legal position is very clear and the law is also in favor of the appellant. The learned counsel appearing for the respondent had submitted that the sale would not be taxed under the Act only if it occasions in the course of import, but the transactions of sale which are subject matter of this litigation had not taken place in the course of import, and therefore they would not be exempted under the provisions of section 5 of the Central Act. In our opinion, the aforestated submission cannot be sustained. They again submitted that in the course of import means the transaction ought to have taken place beyond the territories of India and not within the geographical territory of India. We do not agree with the said submission. When any transaction takes place outside the customs frontiers of India, the transaction would be said to have taken place outside India, though the transaction might take place within India but technically looking to the provisions of Section 2 of the Customs Act and Article 286 of the Constitution, the said transaction would be said to have taken place outside India. The goods that are imported into the territory of India